A number of cases are cited there: Lasisi Adelemu and Alaji Lawal Adetoro, Frank Uwago and the State, Ayo Gabriel and the State, and Oluwari and Oscar, reported variously in 2001, 2008, 1989, and 2012. In view of the above, we hereby further hold that the statement on all the PWM members are decoju and the report attached thereto cannot be relied upon by this tribunal. The petitioners have tendered Exhibits 1 to 192 through PW1. The documents are INEC documents and are certified public documents. Learned senior to the first respondent in his written address has submitted that Exhibits 1 to 192 were merely dumped on the tribunal, and it has been held in the legend of electoral decisions that the tribunal is without jurisdiction to do ex curiae justice by examining them in order to arrive at any conclusion. They refer to a number of cases, a name in Aquabio, that was in 2008, Audu and INEC, number 2, 2010, Chime and Asia, 2009, Sanda and Aliru, 1998. Learned Senior and Council further submitted that Exhibit 4, a card reader printout, is no doubt a computer-generated document which cannot be admitted without complying with the mandatory provisions of Section 84 sub 1 and 2 of the Evidence Act. The exhibit does not pretend to meet or satisfy any of those conditions. It is clearly inadmissible. He submitted. He placed the reliance on the cases of Akeredolu and Miniko, unreported, decided in 2013. The Supreme Court case of Ubo and Dixon, reported in 2013, and Ade Kanya against the FRN, reported in 2005. The Learned Senior Council also submitted that Exhibit 183 and 201 to 217 are clearly public documents which have to be certified in accordance with Section 104 subs 1 and 2 of the Evidence Act and have fallen short of the clear provisions of the law. He asked the tribunal to expand it. He placed reliance on the case of Anyaoha and Obioha, reported in 2014. Learned Senior to the second respondent submitted that the petitioners dumped Exhibit 1 to 92 on the tribunal, and the law is clear that the party rely on documents in proof of his case must relate each of such documents to the specific areas of his case, in respect of which the documents are tendered, and as such, there must be a link between this case and the documents which the petitioners have failed woefully to do. It is therefore not for the tribunal to embark on a voyage of discovery and carry out analysis of the document tendered and come out with the result of its own private investigation. It places reliance on the cases of NPP against INEC, reported in 2010, Kerab and Lawan, reported in 1992, Alawa and Akano, reported in 2005, and Inyama against Apado, reported in 2008, as well as Ebe and APA2, reported in 2005. Learned Senior Counsel to the third and fourth respondent also submitted in his written address that Exhibit 201, 203, 216, tendered from the bar are inadmissible, being uncertified copies of public documents and having not been tendered by the person who made them, as required under Section 83 of the Evidence Act, and that the petitioners did not lay any foundation to qualify for protection under the exceptions which may allow for dispensing with the presence of the makers of the document and INEC forms. He placed reliance on the cases of Okerefia and against Abu, reported in 2012, and Nashidu and Koje, reported in 2003. In his reply, Lade and the senior counsel to the petitioner submitted that the Exhibit 4 did not offend the provisions of Section 84, Sub 1 and 2 of the Evidence Act, and that the principle of law in Kubo and Dixon, cited supra, must therefore be complied. He also submitted that it is right law that the court can look at its record. All the steps taken in compliance with Section 84, subsections 1 and 2 of the Evidence Act were contained in the certified 2 copies affixed to Exhibit 4. Furthermore, the same counsel petitioner stated that both the original and the certified copies of the exhibits have been placed before the tribunal strategically for the purpose of comparison, just in case the first respondent is in any doubt. On this issue, the law is very clear, and as stated by the learned senior counsel representing the respondents, documents tendered in court must demonstrate their purpose and worth through a witness or witnesses. In the instant case, the documents, i.e., Exhibits 192 and Exhibits 201, 203 to 216, subject of contention, were neither tied to nor related to the petitioner's case through witnesses. It is the duty of the petitioners to do so. It is not for the tribunal or judges to do so. They were just tendered through PW1 and from the bar by the senior learned counsel to the petitioner. Although the certified 2 copies, including those of the card readers, having satisfied the provisions of Section 84 sub 2 of the Evidence Act, and the original of the INEC documents, even though not tendered by the makers, but accepted by the tribunal by virtue of Section 83 sub 2, are all admissible evidence. We hereby hold that the documents were made a count on the
Absolutely.
As such, they have no evidential value. See the cases of SN in Yanko and Omisi Ore against Ari Bieshola, Supra, as well as CPC in INEC and Belgore and Ahmed, put in 2013. The petitioners in this petition have alleged various allegations and forms of irregularities, such as self-appointment, non-accreditation, wrong and arbitrary use of incident form. The allegations that the elections in some wards and polling units in Baraka, North, Okolua, Lopi, Ibadan Northwest, Ibadan Southwest, Shaki East, West, Lagelu, Akinyele, Oyo West, and the Ibadan North local government areas were marked by electoral non-compliance arising from multiple reasons of no accreditation of voters, deliberate refusal to use smart card readers, ballot stuffing, ballot papers, ballot boxes snatching, multiple printing of ballot papers, when the election did not hold, chaos, violence, and other forms of electoral malpractice and non-compliance in several polling units, wards, and local government areas. As earlier stated, there is a presumption that the elections were duly conducted in all the wards, including disputed areas, and that all the conditions for valid election were duly met. It is therefore for the petitioners to rebut that presumption. In an attempt to do that, the petitioners have called 29 witnesses before the tribunal, therefore, to now proceed to consider the evidence of the remaining witnesses called by the petitioners and relate same to the allegations made and find out if they have been established. PW2, as we have seen before, is Adam Michael Olushola, PW3 is Okunade Kashu A. PW 4 is Adele Adewale. PW 5 Ogunshola Olawale. PW 6 Amuda Dauda. PW 7 Magoru Muidin Oyo State. PW 8 Folarami Timothy. PW 9 Jumol Man. PW 10 Akinshola John. PW 11 Odewa Sayu. PW 12 Tijani Mufkao. PW 13 Samuel Adebayo. PW 14 Stephen K. Akinala. PW 15 Adekoju Ade Rinto. PW 16 Ogundare John. PW 17 Ogunjimi Yemi Nathaniel. PW 18 Olani Solomon. PW 19 Lami de Yusuf A. PW 20 Ade B. Samuel. PW 21 and Hamid Kabiru. PW 22 Okein Karemi. PW 23 Emiola Azim. PW 24 Ojo Kende Olayoke. PW 25 Ade Tola Ojo. PW 26 Aladi Brian Fire. PW 27 Mr. Kilampo Ezra Adewoyi. PW 8 Olatayo Sarafatin. And PW 29 Eshola Raji Moyo Shore. Now, from the cross-examination of the petitioners' witnesses, most of them confirmed that there was election in their various units, wards, and local government areas. They were accredited and have voted, which is contrary to their depositions, that there are no elections in some units, wards, and local government areas, though they have stated that there were irregularities. But the allegation that there was no election is different from the fact that the election was held but alleged to have been marked by irregularities. The law is very clear on this point. Evidence of witnesses that is contradictory has no value. The case of Awuse and Odili is relied on. Be that as it may, the fundamental question is whether the petitioners have established the allegation according to law. All the learned senior counsels to the respondents have in their final written addresses submitted that the petitioners have failed to establish their allegations. They have made admissions and stated, they have made submissions and stated the correct position of the law in an election petition where the petitioners made similar allegations. We will not bother in this judgment to reproduce their submission. It will suffice to just state the position of the law and then proceed to consider whether or not, by the evidence of the petitioners before the tribunal, they have successfully established the allegations made by them in this petition. For clarity purpose, the allegations and what is required to be established in law will be dealt with in an itemized manner as follows. Allegations of chaos, violence, thuggery, and corrupt practices, etc. These types of allegations must not only be pleaded with detailed particulars of the polling units, wards, and local governments where they took place, they must also be proved beyond reasonable doubt. In addition, the petitioners must prove that the first respondent whose election is being challenged personally committed the corrupt practices or aided, consented to, or procured the commission of the alleged corrupt practices or crimes. See the case of Missouri and another against Ari Bishola and still PDP and INEC in 2012. The petitioners made a lot of allegations in respect of the above criminal acts, but the witnesses spoke did not provide details of the acts and the evidence connecting the respondent with their commission. They only made general allegations, simpliciter, which cannot establish the allegation. As such, we hereby hold, placing reliance on the above authorities, that all those allegations of crime have not been established in this petition beyond reasonable doubt. The next one is allegation of falsification of results. This is a serious allegation in election petition. The petitioners have alleged severally that the results were falsified. The law is very clear. To succeed on this ground, the petitioner is required to plead inter alia two sets of results, one of which could be stigmatized as genuine and the other false. See the case of Sabia and Tuku, reported in 1983. And the case of Hussein Odili, Supra. In the instant case, the petitioners failed to plead and adduce evidence of the results characterized as genuine as well as the one considered fake or false. This allegation we hereby hold cannot stand and must therefore fail. Allegation of bias against returning officers and polling clerks. The law regarding this allegation is also very clear. A petitioner who alleges that electoral officials were biased must adduce evidence to show the manner in which they were biased against the petitioners or in favor of the respondent, which must be widespread and all-embracing to enable the tribunal to arrive at that conclusion. Which is the case of Wari and Massanjo, reported in 2005. The petitioners in this petition allege that the presiding officers and polling clerks acting as the agents of the first and second respondent refused to do accreditation of voters and deliberately refused to use card readers. The petitioners have failed to establish that the electoral officers were the first and second respondent agents and that the acts done by them was in favor of the latter. Mere assertion is not enough. The allegation must be established. Having failed to establish, we hereby hold that the allegation also fails. Allegation that there was no accreditation of voters. The law of accreditation is equally clear. A person cannot vote until he has been accredited, which is done by marking of the voter's name in the voter's register and verifying the voter's fingerprint by using the card reader, etc. It is a very serious allegation. See the case of Fireman Wamiri in 2009. The petitioners have failed to prove this allegation. In fact, the majority of their witnesses have stated that they were accredited and voted, though some of them claim that the accreditation was not properly done. The wrongfulness or impropriety of the accreditation has not been established by the petitioners. This fundamental allegation we hold must also fail. Allegation of non-voting. Under Section 49, Sub 2 of the Electoral Act is amended. The issue of whether a voter has voted is only ascertainable by examining the voter's register to know whether the person's name has been marked as having voted. The evidence of non-voting therefore is by the production of voters' register and the oral evidence of registered voters who were available and turned up to vote at their respective polling units on the day of the election, but could not vote because there were no electoral officers present and that no voting, counting, or announcement of result took place in the disputed wards on that day, and also by tendering the voters' register, which is a public document. See the case of Chime and Onye, reported in 2009, and I would say an orderly, reported in 2005. In this petition, the petitioners failed to call any witness who turned up to vote but could not vote. On the contrary, most of their witnesses testified that they voted after accreditation, having failed to call any witness to state that voting did not take place at any of the polling units, wards, and local government areas. The allegations are therefore deemed abandoned. On the whole, we hereby hold that all allegations of irregularities, non-voting, falsification of results, etc., some of which are criminal in nature, made by the petitioners in the petition, have not been established beyond a reasonable doubt, or even on balance or probabilities.
As court, please.
In the case of warrant item. At this stage, it is necessary to state that even if the petitioners were able to establish non-compliance, which they have not, the law is that an election by virtue of Section 139 of the Electoral Act and several decided cases on the issue shall not be liable to be invalidated by reason of non-compliance if it appears to the tribunal that it was conducted substantially in accordance with the Electoral Act, as in this case. And even if non-compliance is proved, which is not the case here, it has to substantially affect the result of the election before it can be validated or nullified. In other words, if the non-compliance did not substantially affect the result, then the election shall not be invalidated. See the case of Akere Dolu and Bimiko, reported in 2014, and the Haruna against Modibo, reported in 2004. That is senior counsel to the first respondent in his final written address has submitted that the petitioners have abandoned the reliefs they sought from the tribunal by not front-loading any witness statement and testifying in the case, and that for this reason alone, the reliefs cannot be granted. He placed reliance on the case of Abaji and Aine, unreported, which was decided in 2015, delivered on the 26th of August 2015. Learned senior counsel to the petitioners in reply only referred this tribunal to the evidence of PW1 at page 775 of the witness statement of oath, where he concluded that based on what they found, the first petitioner ought to have been declared as a winner. On this issue, we have looked at the entire petition